Welcome back to another video. This video is on YNW Melly. Excuse me. I want to thank all my new subscribers. I really appreciate y'all. Thank you so much. Like, share, subscribe, hit the like button, leave a comment. Please hit the like button. It's free. Keep me in the algorithm. I've been following this YNW Melly case, and he been locked up over 2,000 days, which is equivalent to over 6 years in the county jail. His first trial ended in a mistrial. If the prosecution cannot prove that case, let that boy out. Free him. Now, it just recently came out, though, that the prosecution said they got new footage of him unaliving his two friends. And I looked at the footage and it looked like he might have been standing outside the car, but on the autopsy, they said the bullets came from the back seat from the side where Melly was sitting, when one of the boys' mother had testified. And if it ends in mistrial again, let that boy go home. Karma gonna get him anyway. It is. It is gonna get him anyway. And so if he free, I mean, being in the county jail is shoot. A lot of people that's in the county jail, they just be ready to go to prison, just plead out how bad it is in there. Not saying that, if he did, unalive them, then he getting what he deserved. But the burden of proof is on the prosecution. And they have not been forthcoming. They have not. The judge been on them to give the defense their discovery. They won't even do that. They keep defying the judge's rules. It's just a mess, honey. But that's Florida for you. It's just a mess. But anyway, we just gonna get into this, and then I'm gonna show some videos. Probably be a part two, I'm sure. We just gonna deal with the last week. YNW Melly's legal team requests trial delay to 2026 due to health concerns. So I'm like, now what's wrong with he a young man? What's wrong with him? Rapper YNW Melly's legal team has filed a motion to delay his double murder retrial into 2026, citing concerns over his mental and physical health. Melly has been incarcerated since February 2019, awaiting trial for alleged 2018 murders of his friends Anthony YNW Sack Chaser Williams and Christopher YNW Juvie Thomas Jr. His first trial ended in mistrial in July 2023 after the jury failed to reach a unanimous verdict. He should have been let out then in 2023. I could see him having a mental breakdown. The defense argues that Melly's prolonged confinement under restrictive conditions had adversely affected his well being, making it challenging for him to participate effectively in his defense. They assert that the extended pretrial detention, which has lasted over 6 years, like I just said, has subjected him to conditions more severe than those on death row. Wow. The retrial has faced multiple delays due to various legal motions and disputes over admissible evidence. As of now, the court has not ruled on the latest request for postponement. If granted, Melly's trial will be postponed for an additional year, further extending the duration of his pre-trial incarceration. Damn. Be strong, Melly. So YNW's Melly attorneys believe the rapper's retrial won't begin into 2026. He's been denied bond twice by two different judges. The trial was set to begin on September 6th. I was going to watch that trial. I'm going to watch this trial. Last week, the rap star's legal team unveiled in court documents that the retrial may be rescheduled to 2026 due to appeal hearing. See, it didn't say that in that last article. According to a motion filed by YNW Melly attorney Raven Liberty, an oral argument hearing scheduled for September will interfere with retrial scheduling. Hmm. Wow. So they saying that Mr. Demons, which is his last name, will have been living in conditions worse than death row prisoners for over 7 years. Melly's legal team proposed bond restriction included 24-hour security, GPS monitoring, and house arrest at no cost to the state. During a bond hearing on May 12th, the prosecution expressed concerns that the rapper might flee the country if released on bond. He ain't got no money no more. Outside the retrial date, Melly's motion accuses the court of ignoring multi-platinum artist's constitutional rights, especially his Sixth Amendment protections. Liberty says the judge relied on a 2023 order from Judge Murphy that claimed Melly had felony convictions and gained of it without offering proof. Liberty argues these claims were baseless and outdated. Melly's next court appearance is June 20th. We're going to be there for that. This judge seemed to be a little more fair to me. Oh shit, I done lost it. Look, okay, now let me see. He begs the judge to be released. This is long.
For just $10.99 each, Mix's Match any two-topping Parmesan stuffed crust pizzas. Only at Domino's.
As the court has repeatedly pointed out, Mr. Demings is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
YNW Melly's high-profile retrial is just 4 months away, but the defense is hoping to get him out of jail on bond before that happens.
6 years ago, spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically.
I'm Elizabeth Milner with Law and Crime. Jamel Dimmons, aka YNW Melly, has been in a Florida jail since his arrest in 2019.
Wow.
So more than 6 years ago. And in that 6 years, Melly went on trial, which ended in a mistrial after a hung jury. And despite facing 2 charges of capital murder, the defense is still pushing for bond and offering a number of compromises if the judge allows it.
There's no law nor statute that says, or rule that says we can't come back and argue.
I'm going to let this play because I got I'm baking some chicken.
I agree with you. That's why we're here today.
It was a packed courtroom this week, mainly of Melly's family, when the Florida rapper appeared before a Broward County judge. And before the judge heard arguments about why Melly should or shouldn't be allowed the chance for bond, the judge heard from the lawyer of the victims' families first.
I think the victims, the family members, just wanted us to at least place an objection on the record. Let their feelings be known. Of course, under Marcy's law, they have that right. And so we followed that objection just so Your Honor knows what their position is here, that we would be, a family member would be objecting to any release in this case.
The defense tried to call a witness to the stand to testify at Tuesday's hearing. It was Dr. Heather Holmes, a forensic psychologist. But the state wasn't about to let that happen.
We're going to be objecting to Dr. Holmes' testimony just because she was noticed in the state less than 36 hours ago. She's going to be testifying as an expert. We don't know what documents she should rely upon. We don't know what materials she was given to review. We were going to find comments is going to be the substance of her testimony.
Friday evening, after we had fired her, the state wants to take a 10-minute break. After there was
Okay, I'm ready.
She was
no
listed.
Hold on, let me check my chicken.
Stop.
Let that boy out.
I believe so.
Okay.
Playing court file came in and filed lawsuit about Sunday evening.
So you don't want her testimony to be considered today in the open?
We're fine bifurcating once we, have time to know.
Hold on, I gotta turn my chicken over.
I don't want time to look into that, but today, with what Mr. Griffin said, less than 36 hours, we're not at all prepared to have an expert.
Is she in fact testifying as an expert?
She's testifying as to basically the second portion of my motion going to the appropriateness of the bond. So I am tendering her up there. She did sit with him. She has information to provide to the court.
She interviewed your client?
Yes,
She's going to testify about that?
yes, Judge.
And just so you understand, the e-filing from the court, the clerk's court opening at 10:31.
Okay, so the state's objection is sustained. She's not going to testify today.
So a loss for the defense there, but the lawyers still need to do what they do and argue their reasoning.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove
Okay.
conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight. Is he a risk of flight?
I don't think the boy gonna. Well, shoot, if the boy is gonna be found incompetent to in his defense, then they done already lost. But let's get into these old videos here. This one is from.
Currently awaiting retrial for the murder of two childhood friends, but a new lawsuit alleges he's being held in inhumane conditions. Local 10's Andrew Perez, live at the jail in Fort Lauderdale, to explain this one. Andrew.
Yeah, we have it right here. This is a 12-page complaint. It's against BSO and the sheriff. Melly's family is telling us they haven't spoken to him in years.
Wow.
Break him down and get a result that they cannot get in the court system.
Attorney Michael Pizzi with the family at his side announcing a lawsuit filed asking a federal judge to order the immediate release of rapper YNW Melly.
I was not allowed to sit down with him the same as I sat down with all my clients over 30 years. I was not allowed to show him documents, to have a private conversation.
Wow.
I was behind the glass where I had to yell for him to hear me.
He's been in jail since February 2019.
Wow.
Alleging his constitutional rights are being violated, restrictions interfering with his attorneys trying to help him, and debilitating isolation. He hasn't seen or spoken to his family in several years.
The last time I heard my son's voice on the phone was in 2022. So
Wow.
I don't know if he's alive in there. I don't know if something's happened to him in there.
The rapper, whose real name is Jamel Demons, is
Wow.
Chris Thomas and Anthony Williams' childhood friends. It was after a late-night recording session and allegedly made to look like a drive-by shooting. The first double murder trial ended last summer in a mistrial. The twists and turns that followed throughout included allegations of witness tampering, passing messages, and alleged plans to escape that were investigated. BSO only saying it does not generally comment on pending litigation. However, the jail does not utilize solitary confinement. Mr. Demons has been placed on administrative segregation, an alternate living assignment for someone who poses a serious threat.
Yeah, but he's been in that for years. Come on, he should be allowed. He has a right to contact his family. He's a right to talk to his family and his attorney. Where they do that at? Wow. Free Melly. If he did do it, the burden of proof, like I said, is on the prosecution. If they can't prove that he he need to call home. He need home. Now that's just my opinion.
The judge has been making announcements about YNW Melly's release from jail, as today it would be shared. Update: a judge gave the Broward Sheriff's Office until December 16th to explain why YNW Melly should not be released from prison, after requesting a 10-day extension. If no explanation is given, YNW Melly will be released.
YNW Melly hopes that a new lawsuit filed on his behalf gets him out of prison. The lawsuit accuses the Broward Sheriff's Office of cruel treatment and violating his constitutional rights. The rapper, whose real name is Jamel Demons, is accused of murdering two of his childhood friends back in 2018. Now, he hasn't been able to see or speak to any of his family members for the last 3 years, according to the lawsuit.
However, the
And
concerning
that's
part is that YNW
unconstitutional.
Melly
That is unconstitutional. Well, we know that they did deny the bill, so we know that. This is just, oh damn, I forgot to put, I gotta change that. I should put recap and update. So we just gonna go through these videos. I think it's a shame, but now if he guilty of doing that and the evidence do show that he did that, then this is just karma. But at the same time, he deserved to speak with his family. Ain't no telling, man. And so now he pretty much at his breaking point.
Well, it's been 18 months since rapper YNW Melly's first double murder trial ended in a mistrial. His attorneys are petitioning a federal judge to let him out of jail, and they argue he's being treated unfairly while in custody, not allowed to visit with family or properly meet with counsel. As his second trial looms, NBC6 reporter Marissa Bagg looks back at how we got here and where the case is headed.
Every time I wake up in the morning, I got murder on my mind.
Creating music is on the back burner for YNW Melly. For almost 6 years, the rap artist, whose real name is Jamel Demons, has been in jail, accused of killing two longtime friends in 2018. The Broward State Attorney's Office tried Demons in the summer of 2023 for the murders of Anthony Williams and Christopher Thomas Jr. Both victims were members with Demons of the YNW Collective. The 3-month-long trial ended with a deadlocked jury.
Right. Let that boy out. Let me see, Jay. And I was never really a fan of his. But I just been watching, the trial. My son liked him. Okay, I can let this go. We just did that one. Let that one go. Oh, I have multiple. Okay, now this is the new footage, supposedly.
It is not new information that YNW Melly has been in hot water for years. With the possibility of a death sentence hanging over his head, things couldn't be more serious. But it's his recent footage that's really raised some eyebrows and gone viral, especially because of how he looked. Yes, the man needs an appointment with a barber, but that's not what is getting fans worried about this viral footage. Let's get into the details. YNW Melly appears in court. So let's rewind to February 2019. Florida rapper YNW Melly, whose real name is Jamel Demons, gets arrested and slapped with 2 counts of first-degree murder. The police say Melly and his friend YNW Portland, aka Cortland Henry, did the unthinkable. They allegedly murdered their own friends and tried to stage the scene like a drive-by shooting. Yeah, you heard that right, folks. This is some serious next-level drama. Fast forward to June 2023. Melly's back in the spotlight, not for a new track, but for his high-stakes trial. He pleads not guilty, standing firm on his innocence. But in a dramatic twist, the judge declares a mistrial. But that is not the end of the case, though. Melly heads back to court this fall, and if he's found guilty, he could be looking at the death penalty. Before fall, the man finds himself back in court for his latest appearance, where he smiles as he usually does. For the cameras, however, it was this moment during his last year's trial that has gained attention online. He appears to be praying and then blows a kiss. The mother of one of the victims found it disrespectful and walked out.
I walked out because I don't what you praying for, because you sitting over there like you don't got no remorse. Like every time I walk in, you smiling.
Well, now come on. David was a murderer. Moses was a murderer in the Bible, and God used them. So let's not. Paul was a murderer. He killed many Christians. God used them. So let's not forget that if he did it, God will still use him and listen to his prayer.
You know, this ain't the time for that. This case is sad. This is serious.
Recently, his attorneys have filed a motion to exclude certain phone conversations from the courtroom. These conversations between YNW Portland, Melly's co-defendant, and his girlfriend, Junavia Molina, are deemed irrelevant by the defense according to court documents obtained by Hip Hop DX. The defense argues that the chats are mere small talk with no significant value to the trial and should be considered inadmissible hearsay, thus not used against their client. Now let's talk about Melly's current situation. He's been moved from Broward County Jail to the Paul Rain Detention Center in Pompano Beach, Florida. This maximum security spot keeps a close eye on inmates with the limited movement and visitation through a non-breakable window using a built-in phone. It's definitely a tougher environment. Back in January, Judge John J. Murphy III was honest about pushing this trial forward. He declared that Melly's retrial for the alleged murders of YNW Sack Chaser and YNW Juvie would start on March 5th, or as soon as the case could be heard. The judge is clearly tired of the delays, noting Melly's been locked up for over 750 days awaiting trial.
Right.
But as of now, the trial still hasn't kicked off. This is some high-stakes drama that's got everyone on edge, especially with the potential for the death penalty on the table. This kid from Gifford, Florida was blowing up. Just a month before all this went down, 19-year-old Melly dropped his mixtape, We All Shine, featuring none other than Kanye West, and his track Murder on My Mind had just hit gold. By January 2022, it's certified 6 times multi-platinum. In October 2018, Melly and his crew YNW Sack Chaser, YNW Juvie, Christopher Thomas Jr., and YNW Portland were all chilling at a recording studio. Later that night, Williams and Thomas are found dead. Portland drives them to the hospital, claiming it was a drive-by shooting. Suspicious, right? Especially since Melly and Portland showed up in a music video the next day like nothing happened. Jump to February 13th, 2019. Melly's arrested, and the charges are heavy. The cops say Melly pulled the trigger, and Portland tried to cover it up. If convicted, Melly could be looking at life behind bars, or even the death penalty. Melly, though, stays strong on social media, claiming his innocence and saying, unfortunately, a lot of rumors and lies are being said, but no worries, God is with me. Though that post got deleted later. Melly's been facing some serious charges, but it seems like nothing's bringing his spirit down. Since his arrest, he's been getting mad love and support from the hip-hop community. One big name showing love is Atlanta's very own Future. On Melly's 20th birthday, Future hit up Instagram with a heartfelt shout-out, posting, "Free my little brother Melly" on his story. YNW Sack Chaser's family, on the other hand, are adamant that Melly is innocent. They made a statement to TMZ claiming that they will fully back the state's decision, whatever it may be. Their representative had some strong words saying, "If the state of Florida feels the death penalty is warranted in this case, then we 100% fully support it. YNW Melly should feel the exact fear and panic he so viciously and consciously brought upon his innocent victims." Ooh, that's some heavy stuff. Evidence against him. During the initial trial, the state pulled out some digital receipts to claim that Melly confessed using an Instagram exchange between Melly and Peasy Gambino. On October 26, 2018, Peasy asked if Melly was okay. Melly allegedly responded, "I did that. Shh." But Melly's defense attorney, Stuart Adelstein, tried to poke holes in this by showing that Melly usually spelled that as dat in his messages. Prosecutor Christine Bradley countered this by showing that Melly did use the conventional spelling in some messages, and even in his song, Melly fixed that. They also claimed that the shots came from inside the car. Surveillance footage captured Melly and his crew hopping into a Jeep before the fatal shooting. When the police found the vehicle hours later, Williams and Thomas were dead from gunshot wounds. Ballistic analysis suggested that the shots were fired from inside the car, specifically from where Melly was seen sitting. Although the gun was never found and no gunpowder residue was discovered on Melly, this evidence pointed towards an internal shooting rather than a drive-by.
And my determination was that this is not a drive-by shooting, and it's based upon this picture here, which is a very good picture to describe the shooters at a stationary position when all but one of these rounds are going in.
At some point, the prosecution brought in gang expert Danny Polo to testify about Melly's alleged affiliation with the G-Shine Bloods. Polo claimed Melly was deeply involved, knowing all the signs and using gang lingo in his messages.
And what does hurt mean?
Hurt is a term used by members of G-Shine to refer to each other. It's like calling each other bro or dude, same thing.
The state presented photos and text to back up these claims, suggesting that the murders might have been gang-related, although the exact benefit to the gang wasn't detailed. The state then used phone records to map the movements of Melly and Bortman's phones on the night of the murders. FBI Special Agent Brendan Collins showed that the phones pinged near the crime scene, though he couldn't definitively place them together at every moment. Miramar Police Detective Mark Moretti confirmed that no devices appeared directly at the crime scene due to Melly's phone having its location service. However, surveillance footage helped trace Melly's movements, including when he was picked up by rapper Fredo Bang after the incident. BSO DNA analyst Kurt Rhodes tested various items found in the Jeep, like a water bottle and a spent shell casing, but none matched Melly's DNA conclusively. However, DNA that may have been Melly's was found on the rear passenger side door handle, where the shots were believed to have been fired from. In a bold move, Florida prosecutors plan to introduce a whole bunch of YNW Melly's lyrics as evidence in his upcoming retrial. According to the Miami Herald, Broward County prosecutor Alexander
Free that boy.
found a court document on Wednesday listing an impressive array of Melly's work they want to admit. We're talking 55 songs, 18 audio files, 14 YouTube videos, and 4 album covers. Among these pieces of evidence is Melly's biggest hit, Murder on My Mind. This track, which has been a massive hit and is often seen as eerie given the circumstances, could play a significant role in the prosecution's case. The state is aiming to use these lyrics to shed light on Melly's state of mind and potential motives. Using rap lyrics as evidence in criminal
Hey, Sammy,
trials
how
isn't
you
a new
doing?
tactic,
Hey,
but
love.
it's definitely a controversial one. These lyrics can't be the sole basis for a conviction, but they can be highly prejudicial. Jurors might be swayed by pre-existing biases, often racially motivated against rappers. This can lead them to make up their minds based on stereotypes rather than hard evidence. Take the YSL RICO indictment, for example. Prosecutors used Young Thug's lyrics to implicate him in 10 different overt acts in furtherance of the conspiracy. This case highlights the tricky line between artistic expression and real-life crime. It's a tactic that's been criticized for unfairly targeting hip-hop artists. Young Thug, Gunna, and over 24 associates from the Young Slime Life, YSL, label and artists collective, faced a major indictment on gang.
And one thing about it, the prosecution in YSL, the jury came back and said they did not prove RICO. So, free Melly, for real, free Melly. He been locked up too in a supermax jail. He haven't talked to his family in 2 years and can't meet with his lawyers without glass. That's against his Sixth Amendment right.
Music on trial, which aims to acknowledge rap as artistic expression and limit the use of lyrics in criminal cases. The proposed legislation argues that using rap lyrics in court turns trials into instruments for suppressing provocative speech and undermines the principle that a case should be judged on facts, not on perceived propensity to commit crime. The bill passed in committee in late January.
Thank you, Sammy.
For a Senate and Assembly vote. State Senator Brad Hoylman, who sponsored the bill, told Fox 5
I appreciate my new subscribers, y'all.
Johnny Cash was going to shoot a man in Reno just to watch him die, or Bob Marley shot a sheriff but spared a deputy. But that's exactly what prosecutors are trying to convince juries about across this country.
The legislation, unveiled in November 2020, took a significant step forward on Tuesday, October 12, 2021, successfully passing through the Senate Codes Committee, marking its initial move toward a full Senate vote. Jay-Z has also lent his voice into this issue. His lawyer, Alex Spiro, has said, "This is an issue that's important to Jay-Z and all the other artists that have come together to try to bring about this change. This is a long time coming. Mr. Carter is from New York, and if he can lend his name and his weight, that's what he wants to do." Jay-Z's lawyer, Alex Spiro.
Right. They should not be able to use rap lyrics in a court of law. I support that.
A partner at Quinn
But let me
Emanuel,
go.
this potential and pitfalls. Still not sure how that matters.
Lord.
Let me take you through a small digression.
Now he about to watch do Tay K, and I did Tay K's last trial. It's in a video, and he already got 55 years for the first murder. They came back and gave him 60 years, so he gonna die in there. And I'm just like, and he was a young man, so now they about to go on what happened with Tay K.
To Tay-K. In July 2016, Tay-K was arrested and charged with capital murder for his involvement in the home invasion. Due to his age, he was placed under house arrest while awaiting trial. However, Tay-K had no intention of staying confined. On March 27, 2017, Tay-K cut off his ankle monitor and fled. His escape turned into a nationwide manhunt, and Tay-K documented his life on the run through social media and his music. During his time as a fugitive, Tay-K traveled across several states, evading law enforcement and continuing his criminal activities. While on the run, Tay-K was involved in another murder. On April 23, 2017, in San Antonio, Texas, Tay-K allegedly participated in the robbery and shooting of 23-year-old Mark Anthony Saldivar. Witnesses reported that
Anyway, so he ended up getting additional 60 years. And when they had a psychologist come up there, and I have to say, his defense attorneys did the best that they could do. I felt so bad for Tay K based on his life, what he had been through growing up. And it's like he ain't never had a chance, Tay K ain't never have a chance to win. But let's get back
behind him,
into
launching
Melly.
social media campaigns, petitions, and hashtags like #FreeMelly, calling for his release in a fair trial. They argue that the justice system is punishing him prematurely without
Facts.
conviction, and that he should be granted bond while awaiting trial. Conversely, critics of Melly point to the severity of the charges and the potential danger he could pose to the community if released. They cite the need for justice for the victims and their families, emphasizing that the safety of others must be a priority. The media has played a significant role in shaping the narrative around Melly's case. News outlets and true crime podcasts have delved into the details of the charges, often drawing comparisons to other high-profile cases, such as that of Tay K. The sensational nature of the allegations, combined with Melly's celebrity status, has made the case a fixture in tabloid headlines and online discussions. The fear is that if Melly were to be released on bond, there is a risk, however small, that he could attempt to flee or engage in further criminal activity. This concern is amplified.
This is
by
Rap
the
Daily.
notoriety and influence that come with his status as a successful artist. The judge's decision to deny bond reflects a desire to mitigate these risks and prevent a repeat of the Tay K scenario. The implications of Melly's prolonged detention extend beyond his individual case. It has sparked discussions about the balance between the rights of the accused and the need to protect the community. Advocates for criminal justice reform have used Melly's case to highlight the broader issues of bail reform and the conditions of pretrial detention facilities. As the legal proceedings inch forward, the court of public opinion remains divided. Melly's supporters continue to clamor for his release.
Yes.
Others stand firm in the belief that the seriousness of the charges justifies his continued incarceration. The media continues to follow every development, feeding the public's insatiable appetite for the latest twist in this ongoing legal saga. Judicial considerations are heavily influenced by the nature of the charges against Melly. First-degree murder is among the most serious charges in the criminal justice system, often carrying the possibility of life imprisonment or even the death penalty. In such cases, judges are more inclined to deny bond.
Free Melly. The burden of proof, like I said, is on the prosecution. Okay, because I like to do an hour. So it'll be a part 2 and 3. You know how I do because I have so much information. Oh, I'm going to do that mayor. I'm going to do that mayor. Yup.
I'll speak in my office and we can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation.
Facts.
We had to learn this from Apple.
The prosecution will not give the defense information. They will not give them discovery. Free Melly.
Well, it turns out that YNW Melly has some motions today, but
This city cast.
be heard because we just found out 2023, one of the lawyers, I guess, was not even supposed to be on the case this long in because she has an active investigation, which we believe is for witness tampering, but we don't know because they haven't told anybody. Man, it get real messy. I'm talking about
It sure
to your
do.
house messy. Let's just get into it.
Oh shit, I got some old stuff on here.
As much as the federal case law does, indicates that there are certain things we need to find out first of all. So I would vote if this is the hearing or you want to set a hearing. But the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's
This is because his attorney is under investigation, though. So this prolongs it as well.
The reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they subpoenaed other things.
Facts.
Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty.
That's right.
She has not received
And they have not.
She didn't know
They dirty.
that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago.
Facts.
So the defense
Facts.
and Miss Liberty, and therefore Mr. Devins, for a year, are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that's been waived up until that time, I think the case law is pretty clear.
I don't know what happened. I must have hit something. I don't know, but this is awful how they doing him. The burden of proof is on the prosecution, and they haven't done it.
I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sub 1289, 2009.
In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial, where the government to inform the court at the eve of trial or during the course of trial the defense team was under investigation for witness tampering. Under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shaken. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of the defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Deming's trial, we may be forced to, under the law, to withdraw as an entire defense team.
So
wow.
the question is,
wow.
Yo, why are y'all doing this now?
Exactly.
I think the state maybe hitting them with that petty grease, because if you remember, the state had to basically remove their head person because she just became a freaking witness in the trial.
Yeah.
So the blonde hair lady that you see now is not the lady that was who we were used to. We used to the lady who, I'm gonna be fair, has zero sense of emotional tone. She couldn't convey the right words in the emotional intelligence that you need to. See, it's one of those things where there's a subtle art of public speaking that you need to have when doing certain things to them to feel, such the pain from having another person or the anger that you may feel.
Hold on, let me get this chicken. Let me let this
Just those things alone are supposed to do something for you. But in this instance, she didn't have any of that. So now we got to sit back and wonder, hey, bro, why are we doing this now? Basically a couple of months out from the trial, because he's right. Hey, man, listen, some BS can happen.
Right.
We all have to withdraw. And it seems as though y'all still trying to concoct y'all case so y'all can figure out how, one, y'all didn't answer these motions. All y'all did was ask for extensions on these motions.
Facts.
You've been in jail for I think the judge is going to reveal 1,165 days.
Now it's
like
2,000 some days.
Come out pretty soon, but let's just keep on going.
But the question still needs to be asked.
Damn, and then the damn thing that went. I got about 20 minutes. Yeah, free Melly, y'all. Y'all ain't proved your case yet. What y'all doing to that boy is so wrong. Now, if he did that crime, you still got to prove it. But he could be at home fighting this case. I ain't never heard of nobody being in a county jail as long as Melly ever fighting a case. And it ain't been resolved yet. And he ain't talked to his family in 3 years and got to talk to his attorneys through glass. Where they do that at? So he got a lawsuit, and I hope he wins. I done lost all where I was as usual. Just give me a minute, y'all. I lost my spot as usual, y'all. Just like, share, subscribe. How y'all feel? Do y'all feel Melly should be free while he fight this case on bond? Where you gonna go? You put a GPS on him. I should have looked at this at the bottom. Oh, is it this one? Let me see where this phone at. Let me see where this phone. Remember, I think this one move faster. Yep. Oh no, it don't. No, it don't. It don't matter. Shit, no, it don't. Yeah. I hate when this happens. Just hold on, y'all. I lost my place. Damn, I can't stand when it does that. I'm working off two phones, y'all. Working on two, whichever one get me there. I hate that. Oh no, I got 20, 15 minutes. I might just have to end it here, but I don't want to. Damn, I want to get this, so it's gonna have to be a part two. But how y'all feel? Free Melly? Do y'all feel Melly should be free while he fight this case? He was a mistrial the last one. It's gonna be a mistrial this one. Y'all is, the state ain't proved a case. As far as I'm concerned, the state have not proved a case. And Melly, man, come on. I have so much. I hate when my phone do this. I have so much information. Just give me a minute. Damn, I was doing good. I'm working off two phones. Just give me a minute. I lost my place. As usual, the dang on thing always do that. But put it in the comments, do y'all think YNW Melody should be free? I'm almost there. I'm working off two phones. Oh shit. I want to get all the way back here. It shouldn't take all day, man. I'm gonna probably go a little over 15 minutes since I'm trying to get my place because I try to keep my videos down to like an hour. End up here. I'm just gonna have to do it here. Oh, damn. I shouldn't have all the information I have. Thank you for your patience. Cause I'm sure trying to get back to where I was. I just have so much information. And when this computer just flip flop and do the for floppy, it just mess up everything. And I have to get back to where I was. Oh shit. No, this somewhere else. Alright, I'm just about there now. Almost on the 6th. If I'm gonna let this play a little over 15 minutes, it don't make no damn sense. We just gonna have to do that. At least I'm almost in the vicinity of where I was. Damn, don't make no sense. All right, here we go. All right. All right, here we go. Here we go. Here we go. All right. I'll go back to where I was. Okay, here we go. Let me delete the video I just did. Get that out my phone. Okay, we're going to delete that one. Cool, that's gone. Here we go.
Melly had his first court hearing today for his upcoming trial in September. The new judge was stunned to hear how long Melly's been sitting inside of jail. It begins with Melly walking into the courtroom looking irritated with a new hairstyle. And Melly's angry for good reason, but more on that later. The new judge began reading over the case files until he stumbled on Melly's jail time. It was reported Melly has to make an informed decision about who he wants as his lawyers. He's now been sitting in our jail for 2,159
Facts.
days.
Free Melly.
Everyone, including Melly, surprised.
Let me repeat myself. Mr. Demons has to make an informed decision about who he wants as lawyers. He's now been sitting in our jail for 2,159 days.
Wow.
So, how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week, and then I'm asking for at least a day or two.
You can decide by tomorrow. I've also reserved all the way tomorrow.
The judge couldn't believe Melly's been sitting in jail for 2,100 days without a conviction. He said, give us your final reason why he shouldn't be free by tomorrow, or I'm releasing him on bond. This is exactly what Melly needed, a new judge who won't just side with the prosecutors. However, to help Melly's chances of release, his lawyers brought up this evidence from the original trial of Melly, texting his ex-girlfriend in real time when the crime went down, when he was running away from the men on the street.
That would be the part where he's saying that someone the car was trying to shoot him. So I asked him if he was okay, and he was, and he's like, there's cars coming behind him, like, I think they're still out here. So I'm like, you okay? He's like, I'm okay. I said, well, where are Zach and Judy? And he said, I don't know if they're in the car. I think they're
proving Melly was being chased by a car with rival street members in it. But also in the Melly trial, prosecutors admitted there was no firearm found.
So the first thing is I didn't have a firearm, so I can't know which I'm going to use in order to replicate any of my tests. So I can't make tests for this determination because I don't know what was used.
okay.
To understand Melly's release date, you need to understand why they're finally pushing the release talks through court. Boozy revealed the feds are doing whatever they want with Melly, whether it's legal or not, but it seems they've been caught.
Now they're putting even more charges on him, and then
when they want you, they want you. I knew they wanted him bad when they waited for that law to get passed. So it'd be 8-4.
Wow.
They waited all the way till that law got passed to take him to trial.
Yeah, he was in the jail for what, 2 years, 3 years?
Wow.
They could have been took you to trial.
You're right.
They waited till that law got passed and took him to trial a couple months later. When they want you, man.
That's
Just
true.
don't see how he didn't get a bond after a mistrial.
That's what I'm saying.
That made me like, God damn.
That's what I'm saying.
Like, after a mistrial, that doesn't happen, really.
This has been Melly's reality for the last 5 years, with the feds being able to do anything they want to him. which is why Melly's mother is now suing the county jail to have her son released from jail. A report shares Melly sues Broward Sheriff's Office for cruel treatment and is seeking immediate release from prison. Melly also claims that they have not allowed him to see or speak with any family members in 3 years. Also not even being allowed to use a phone or even look at his mail.
My son has not been convicted of anything, and even other inmates that have been convicted or anything, they have the right to They have a right to just to be allowed to write letters to their loved ones, to receive their mail. They hold his mail, they don't give it to him.
As Charleston White reacted to this, sharing that this is what Melly should be living like and shouldn't get special treatment.
The YMW Melly. I'm so happy he in jail getting mistreated. Yeah, I'm so happy. You take a life, homie. You ain't got a right to complain about a motherfucking thing about being mistreated when you done chose to play somebody.
This made Melly's mother extremely unhappy. Jamie King reveals she feels heartbroken and helpless, as Melly's not even being treated as a human in jail.
When you saw Melly's statement, just saying how he's been hurt, how he's scared for his life, as a mother, how did that make you feel?
It's heartbreaking.
Wow.
It made me feel completely helpless. Broward Sheriff's Office definitely needs to
Free Melly, y'all.
I mean, they are making up their own rules. We tried to go to court about this situation. The judge really doesn't have any jurisdiction when it comes to the jail, because we actually had a hearing about the mistreatment of him, and the jail they make their own rules. And I don't think that's fair, because I know that they need to answer to someone too.
This would get the attention of Boozy, who would speak on the stress Jamie King's been going through.
She real, bro. You know, she real. She's stressed out. I heard she had a... Yeah, she real, and I reached my hand out to him, cause I'm real. Yeah, I reached out to him, bro. I met his mom, and she a good woman.
But the feds would retaliate by creating a 6-page evidence file explaining the reasons why Melly shouldn't be released from jail. You tell me if you would release him. Starting with the most important new piece of evidence, which is what the motive was. Melly was very close with King Von, leading to his arrest. A rogue O-Block member shared a secret Melly told King Von. Melly asked King Von for advice on how to handle a situation with Sack Chaser and Juvie.
Did Von really tell you that Melly told him that he was two friends?
He ain't come out and say, like, we got into an
Oh,
argument.
this J Hood.
And so, if when people can say something without saying it. And so he told me, like, once I posted what I posted, Von was mad at me, bro. Why you put that, bro? Walk the bam. I'm like, you sitting up here, like, you know the love we got. You do this for us. But you gonna trust that it's two friends? And he said, they was trying to extort him. And so I'm like, if they was trying to extort him, then why are you still around them?
Involving Sack Chaser and Juvie going after Melly for financial gain, as it's a registered business where Melly and Bortland performed concerts, sold merchandise, and did promotions for companies in exchange for money. However, Sack Chaser and Juvie wanted a cut of the money but did zero work for it. But if you know about King Von's past and how he handled situations, you can guess how Von would have told Melly to handle it. This was the missing piece of evidence the prosecutors missed during the original trial, which is a motive. Pair this with evidence found on Melly's phone, and it gets bad, where he sent a text message hours after the crime admitting to it.
The PC Gambino town asked him if he was okay.
That's not an admission. No, it's not.
And placed a smiley face emoji.
And the next message from 10/26/2018 at 16:02 from Eastern Standard Time. The YMW Melly count says what?
After that, SHHHH.
But also found on Melly's phone was a saved video from someone's Facebook Live. It shows Melly and Bortland's reaction to the crime only 6 hours after it's done.
Melly still turned regardless of what happened this early morning. He's still out here being very positive. Hurt still. Hey. Still hurt, regardless of what happened. You heard?
showing not an ounce sadness for the passing of the two best friends. Knowing how Melly handled it emotionally, the lead prosecutor would then dive deep into the physical evidence of the crime, such as the Jeep they were driving in. During the original trial, Sergeant Williams revealed there was no way this could have been a drive-by.
Number 17 outside the car. How many rounds were inside of the car?
3.
Damn, inside the car?
Can you exclude the for Mr. Williams and Mr. Thomas is coming from outside the car?
Yes. From the driver's side back seat.
As to Christopher Thomas, where did that name from?
Driver's side back seat.
No. Is it possible for there to have been 2 inside that car?
No.
Why not?
There is no time assignment, which is to determine if this is a driver.
Wow.
And
The state is caught lying right here. You know what? I'm going to let that one wait a minute. Before I hit that, I'm going to end with the state being caught lying.
Reveals that the state filed a search warrant for one of Melly's defense lawyers, Raven Liberty's Apple iCloud account. Yes, you heard me correctly. Broward County Sheriff's Office is investigating one of Melly's lawyers, and they have access to everything that was in her Apple iCloud account. Doesn't that seem like it's not fair?
Right.
That just seems like crazy to me, right? I'm gonna read this motion though. Hit subscribe. Here we go, boys. First thing we got here is order prohibiting use of Zoom communication technology. On December 5th, 2024, this court conducted a calendar call for State of Florida versus Jamel Demons. Since live in court proceedings resumed in 2021 following the pandemic, this court has used Zoom communication technology on a daily basis to allow attorneys and parties to appear remotely and also to allow the public to observe court proceedings remotely. Okay, so yeah, obviously they still use Zoom in some situations. This court has set up the Zoom communication technology in a manner that allows attorneys and parties in the public who join the Zoom meeting remotely to always see and hear everything that is said. However, the attorneys and parties and the public who are actually present in the courtroom are not able to see or hear anything that is said on the Zoom meeting unless this court activates audio and video equipment in the courtroom 4780. The setup allows the undersigned to activate the Zoom audio and video when an attorney or party appears remotely, but otherwise prevents additional audio and video from being broadcast in the courtroom to maintain the dignity and decorum of all court proceedings. Okay, what's going on here? Why are we putting in shit about the Zoom, dude? On December 5th, 2024, at least 5 participants in the Zoom meeting broadcast inappropriate material, including multiple images of nudity and pornography. No way that happened, bro. So the Zoom got leaked and people went in and blasted porn everywhere. This happened in the YSL trial too. This court notes all of these participants were admitted to the Zoom meeting after identifying themselves as an attorney, party, public observer, or the legitimate participant. These images also included written messages in support of the defendant and written messages requesting to free the defendant. This court notes all the legitimate participants in the Zoom meeting were exposed to the inappropriate material, including multiple images of nudity. This court was forced to halt all court proceedings, and subsequently this court was forced to end the Zoom meeting.
Wow, they came in naked.
And also delaying the continuation of jury selection in an unrelated first-degree murder trial.
Wow.
Zoom hacking delayed the whole court's day, dude. This court's already able to
wow, so they hacked one. Wow, they hacked this Zoom, came in there naked. Wow. You can't make this up. You cannot make this up. What is that? 10, 16, 17. I'm going to do these last 3 videos, so at least I'll be almost caught up with Wind Up and come back with part 2. Free Melly. Let's see. This is supposed to be his release date.
According to a recent source, the new judge in Ryan W. Melly's case is assisting Melly in getting out of jail. Judge Fye has a reputation for being the most even-sided judge in Florida. Perfect for Lion Duty Melly, who has been mistreated and taken advantage of thus far. Which is very true, as he was even surprised when he was reading Melly's file. It would be announced. Melly has to make an informed decision about who he wants his lawyers to be. He's now sitting in our jail for 2,159 days, says the judge.
Facts.
As while the judge was reading that out loud, he was very surprised.
Let me repeat myself. Mr. Demings has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So, how long would you like to be able to make that decision?
I can't determine when we do that decision. We open that up to our sheriff's office, but I can have them, as I said, I'm just asking for a week, and then I'm asking for at least a day or two.
Decide by tomorrow.
The court urged the
terrible how they treat. But now, if he, like I keep saying, the burden of proof is on the prosecution, and they did a piss poor job of trying to convict him. That's why it was a mistrial. I just want to clear out these last two videos because I got the video I'm going to end with. Okay, here we go. We on there. Here you go. The prosecution is corrupt. Here we go. Show you the prosecution corrupt.
To hand over the search warrant by January 14th for Melly's defense lawyer's Apple account. And take a wild guess if the state handed it over. Of course not, because they filed a memorandum of law and a protective order request. The state basically asserts that Raven Liberty can't be Melly's lawyer anymore. And they straight up disobeyed the judge's order. So he's going to be livid. I'm going to read the full document here. Hit subscribe. Here we go. Our first thing we got here states a memorandum of law regarding attorney conflict. On December 27, 2024, the defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18, 2024 by Apple that on December 13, 2023, that her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. Monday, January 6, the Honorable Court heard the defendant's motion, and the court ordered her to hand over the search warrant. That's what he did, right? On January 6, 2025, the state filed a motion for rehearing reconsideration to compel disclosure of Apple search warrant related to attorney Raven Liberty. Within this motion, in paragraph 11, the state mentions that regardless of the details of the investigation, Ms. Liberty has an ethical obligation to withdraw even if the defendant were to waive the conflict. So straight up, the state is saying she needs to withdraw and not be his lawyer anymore. Kind of crazy, right? And
right.
Versus P. Zona, 2006, the court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified notwithstanding defendant's desire to waive. If the activity for which the attorney is investigated is substantially related to the charges against the defendant, disqualification is necessary, notwithstanding the defense waiver. At one point, they said it wasn't related to the charges against the defendant. Stewart even pointed that out. He said, is it related or is it not related? To the judge, I don't know if we ever got an answer or not. Well, no, she said it was related to Melly, but not the
so
other
they
charges.
Trying to get his attorney thrown out. This prosecution is dirty. They not giving the discovery to his defense. Okay, we're going to do this one. We got one more after this.
I actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit. Ms. Tom, let me ask you this. I read your authority. Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Can you explain that to me? Because if I sign a search warrant for someone's home, the DSO goes to their home and executes the search warrant, and they're there, they give them a copy of the search warrant.
Correct.
Upon its execution.
It's Apple that the warrant is being executed upon, not the party themselves.
And you think their authority says that she's not even entitled to a copy of the search warrant?
Wow.
That's correct, Judge. Yes.
That's your position?
Yes, Judge.
Okay.
Unbelievable. Unbelievable.
The state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today so you can litigate that as you see fit. But
Right.
I certainly think she's entitled to a copy of the search warrant. Probably that's it at this point. So, defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date.
Well, Judge, she said, nah, check this out.
Horrible.
I had to pop up to the YNW Melly trial. I'm definitely had to start a GoFundMe for this one.
Right.
State of Florida versus Jamel Dimmons. States memorandum of law regarding attorney conflict comes now to state of Florida by and through the undersigned assistant state attorneys and submits this memorandum of law regarding attorney conflict and comments as follows. On December 27, 2024, the defendant filed a motion for hearing to determine potential conflict. In this motion, it states the defendant's attorney, Raven Liberty, was informed on December 18, 2024 by Apple that on December 13, 2023, that her Apple account information had been provided to the Broward Sheriff's Office pursuant to a search warrant. Monday, January 6, 2025, this honorable court heard the defendant's motion. In addition, on January 6, 2025, the state filed a motion for rehearing, reconsideration of defendant's or tenant's motion to compel disclosure of Apple search warrant related to attorney Raven Liberty. Within this motion, in paragraph 11, the state mentions that regardless of the details of the investigation, Ms. Liberty has an ethical obligation to withdraw even if the defendant were to waive the conflict in U.S. versus Pisonia. The court held that if the attorney suffers from an actual conflict so severe that it impedes effective assistance, counsel should be disqualified, notwithstanding defendant's desire to waive if the activity for which the attorney is investigated is substantially related to the charges against the defendant. Disqualification is necessary, notwithstanding the defendant's waiver. On Tuesday, January 7, 2025, this honorable court entered a written order ordering the state to provide a copy of the search warrant to the defendant to determine his potential conflict over the state's objection. Over the defendant's objection, this honorable court ruled it will review the search warrant.
How the state not going to give the defense a search warrant? Unbelievable. Corrupt.
For potential redactions. During this January 7, 2025 hearing, this honorable court spoke to the defendant about how it was his decision and his decision alone to determine whether to keep Ms. Liberty as his counsel despite this conflict. It is not the defendant's decision. The United States Supreme Court has recognized that the Sixth Amendment right to counsel is circumscribed in certain situations. See Wheat versus U.S., explaining that the Sixth Amendment right to counsel is premised on the site that a defendant is entitled to receive a fair trial, though the adversarial process in the relationship between counsel and defendant must give way to that right. The United States Supreme Court also explicitly rejected the argument that a waiver of the conflict cures a violation of the Sixth Amendment. To the contrary, courts have a legitimate interest in ensuring the criminal trial is conducted within
they violating his Sixth Amendment right to counsel. You can't make this up. And the prosecution still hadn't handed over that. They have a right to the search warrant. Unbelievable. This is the last video. I wanted to end with this one. And then it'll be part 2.
Understand what's going on this morning. YNW Melly appeared in court today for motions, but of course something went wrong. The state was caught lying on a motion, and defense lawyers
caught lying.
The judge also orders the state to hand over their Apple iCloud search warrant of Melly's defense lawyer's Apple iCloud account. At one point, Melly has to speak to the judge, so we actually hear him talking for the first time in a year and a half. Pretty wild stuff, though. Hey, subscribe. Here we go, boys. Oh, there's Raven Liberty. Looks like she made it. And there's Stu. Oh, there's Melly's mom. Oh, here comes Melly. Let's see if we get anything productive done today. These two aren't allowed to talk in person, really. She's had to talk to him in one of those glass partition rooms. I really want to know what she just whispered there. 2,100 days in jail, that man's still smiling. Smiling at his mama.
2001, and haven't talked to his mama in 2 to 3 years.
Raven Liberty got some crazy eyes. Look at this. She looked crazy as hell. All right, audio finally came on. Judge came in. Let's go.
Okay, so this is just a continuation of yesterday. I did get, and I read the state's motion for rehearing and reconsideration of the Apple search warrant related to attorney Raven Liberty. I don't know that I actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit.
Let's see if they actually turn it over. I'd say it's like 50-50 chance that they come up with an excuse to not turn over the search warrant and affidavit.
Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Told you.
Wow, unbelievable. Free Melly. Free Melly.
If I signed a search warrant for someone's home, the BSO goes to their home and executes the search warrant and they're there, they give them a copy of the search warrant.
Correct.
Upon its execution.
Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
That's correct, Judge, yes.
Wow, unbelievable.
For the channel, please hit subscribe. I appreciate the support. Back to the video.
Yes, please subscribe.
I don't understand what's going on here.
I don't either.
Over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today so you can litigate that as you see fit. But I certainly think she's entitled to a copy of the search warrant.
Absolutely.
Put on the table and said, "You're giving it over." Let's go, boys.
Defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is I need to give you a date very soon in the future. It's a date in February that we're looking at. And at that point in time, you're going to have to come back in here and tell me, and I'm going to have a discussion with Mr. Devins. I'm going to start that discussion this morning so he understands that he's the captain of the ship. This is his decision, but he's going to have to tell me if he wants Ms. Liberty to continue to be his lawyer or not. He's going to have to tell me if he wants all of you to continue to be his lawyers or not, or he's going to have to tell me that he's going to seek other counsel, but I think that needs to happen sooner rather than later.
We concur with that.
Looks like he already made up his mind, low key. The way he just looked at her, feels like he gonna be like, "Fuck it, let's just go on. I don't need new lawyers."
Right.
He's gonna delay it more. He's gonna trial 9 months.
Unbelievable. The prosecution corrupt, just like in the YSL case. Prosecution was corrupt.
This motion for reconsideration and not.
There was no motion or ruling. I think she's entitled to. I think. Listen, Mr. Devins is entitled to heightened due process.
Exactly.
The death penalty. It is very clear that one of his lawyers is under investigation right now. He is entitled to have as much information as I have the ability to give him.
Right.
Before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, he's the captain of the ship.
Absolutely.
He makes this decision. If you all had some other authority that says I have some additional power to assist in the fact finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority, or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is a. I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Devins wants to do. This is completely.
Anyway, he kept his attorney, but this is corrupt prosecution. He has a right. His attorney has a right to the search warrant of her iPhone. Like, share, subscribe, leave a comment.